Hello, my name is Randall Borden. This is my podcast. I have as a guest today Samantha Seltzer Cohn. Did I get that last name correct?
You did like ice cream. Thank
Ice
you.
cream. Okay, got it. Thanks. She's a trial attorney in Virginia. She's admitted to all the Virginia courts, United States District Court, Eastern District of Virginia, United States Court of Appeals for the Fourth Circuit. And she's got a distinguished trial record with over 1,000 trials. And she's going to hopefully tell us the secrets to her success today. So, welcome aboard. And I guess the first question is, if you could point to one thing that made you successful, what would that be?
Well, first and foremost, Mr. Borden, thank you for having me. It's a pleasure. I appreciate
Sure.
you inviting me and being here today. I think probably what one thing that has really led to my great success is probably authenticity. And I really struggled with that, as we all do when we're younger, figuring out who we are and where we're going. And I actually didn't go to law school until later in life. I didn't
Mhm.
graduate from law school until I was 31. It took me a little bit to find my path, although I
Right.
did grow
Mhm.
up in a family of attorneys. So
Yep. Same here.
Um, yes. Well, we're Jewish, so it was doctor or lawyer. These are my.
Oh, absolutely. Yeah.
I've really found, particularly when connecting with both clients and the jury, that
Mhm.
authenticity is really key. Juries can smell a story from a mile away. If they don't believe you, they're not going to believe your client. It doesn't matter
Mhm.
how authentic or real your client is or how honest. If they don't believe you, then they're not going to award your client anything. Also, dealing with clients, it's kind of the same thing. You have to build that trust relationship. And if they think that you're not being yourself, then they don't trust you and they're not going to open up to you. So I
Mhm.
think with connecting both with clients and the jury, authenticity has really been key. And I've watched a lot of other attorneys kind of struggle with that and kind of find who they are in a courtroom because you are telling a story and you're presenting it. And it's important to be mindful of how you do present it. And if somebody, again, comes off as inauthentic or not being honest or truthful, the jury is immediately turned off.
They're there sort of by invitation, and you'd better make their time worthwhile and give them a good reason for being there. And they're there to do a job, represent the community, and put justice out there into the world. So you need to help them do their job too, I guess. I see the kind of the same authenticity in family law, that you have to tell the client you have a bad case, or the spouse's attorney is going to eat you alive on this, and you'd better wait for a while and try to clean up your act, or stop drinking, go to AA, get some of those AA coins, have a few of those with a sponsor to testify in court if you want to see your child without supervised visitation or something. And or I tell them, don't do anything now. Sure, your spouse is talking about divorce, but everybody does that. It's nothing to react to now. So you built up a long-term, I guess, a system, right? That you have advertising, you bring in the client, meet with them, tell them what their case is worth. You have the paralegals that process the work and then present it to you for trial. Is that the arrangement?
So I'm at the Smith Law Center and the Brain Injury Law Center, which is located in Hampton, Virginia,
Mhm.
although we travel throughout the country. We actually, our managing partner had an 8-week trial in Oklahoma this summer with a
Oh.
$10 million verdict that he got from a traumatic brain injury. So what we do is actually, the Smith Law Center has been around for 75 years,
Hmm.
and it was started by Joseph Smith, and it was really to service kind of the marginalized demographic of Hampton Roads, people that
Mhm.
back in 1949
Hmm.
weren't getting proper representation, whether it be religious or ethnic reasons. And then his two sons, Stephen and Howard, took it over, and they still remain and they're still practicing.
Hmm. Okay.
And then there's also David Holt and Stuart Gill. And there's myself, and then now we brought on Katie Carroll. So, given that the firm has been around for 75 years, there's actually not a ton of advertising right now. It's
Oh,
a
okay.
lot of word of mouth. We have
Mhm.
third, fourth generation clients coming in, which is
Mhm.
wonderful. And I think speaks volumes to that exact client relationship that the firm really purposefully and mindfully builds. And so they contact us. We do have an intake department. We have a great intake team. They contact the intake team or they contact one of the attorneys and we transfer them over to the intake team. The intake team gathers all the details, puts everything together for us, kind of gets the background, and then shifts it over to a case manager. And then that case manager is in charge of the case and handles the case pre-litigation. So client communications, making sure again that we get everything in, such as police report, health insurance information,
Right.
lost wage information, where are they treating, all the medical bills, how they're feeling. Make sure that we just have everything that we need. So when it does move over to litigation, if it does, we have all of the resources and tools and information. So the pre-litigation case manager handles it. And then the hope is actually that as much as I love litigation and going to court, the hope is that the case settles. We don't want to spend time. We don't want to spend money. And I say that as in the client's time and money. We don't want to have the client wait for years and years and years to get a resolution. A lot of times, a lot of the cases that we handle, the people can't work anymore. And so money's tight, especially particularly during the holidays.
Right.
It's really, really difficult. We want the case to move as quickly as possible. And we would hope, I don't know if it was clarified, I'm a personal injury attorney. So
Yes,
mainly car accidents and some premises like slip and falls at like a grocery store. So usually we would want the case to settle pre-litigation. Unfortunately, we have some cases where our clients have catastrophic injuries and they continue to treat beyond the 2-year statute of limitations. If we tried to settle it before that, it would be shortchanging our clients because settlements or verdicts are typically based on the medical bills and their costs. And the projected amount you can expect to recover is generally 2 to 2.5 times your medical bills. Now, that can go up or down depending on the severity or lack of severity of the accident. If you went to one ER visit, you're not going to get 2.5 times your medical.
Right.
However, if you have a catastrophic traumatic brain injury and you're never going to work again under, horrific circumstances, that the person was drunk and they ran a red light and were driving 20 miles over the speed limit, you're looking far beyond that now.
Right.
2.5% or 2.5 times. So the case manager handles it. Hopefully at that point, we can put a demand package together and send it to the insurance company. The insurance company is not your friend. They don't care about you. You are a number. I don't care if you've been with Allstate for 25 years. You are money in their pocket. They do not care. I don't think people realize that not only does the insurance company take everything you say to them and use it against you at a future point if they have to, it can be as bad as you have 2 types of insurance. You have liability insurance, and then you have underinsured motorist and uninsured motorist coverage. And when that gets triggered, that's your own personal coverage. Say the person who hit you didn't have enough to cover your injuries. That coverage gets triggered if you have it as part of your policy and it's available to you. Your insurance company will hire an attorney to represent them, to represent the defendant, to fight you for your own policy coverage that you have paid for. You're facing a Goliath. You're already behind the 8 ball. They don't care about you. We put together this demand package. We hope that the insurance company treats you reasonably. We hope that they come to the table and they negotiate in good faith, and then we can resolve it. We hope that before the 2-year statute of limitations comes up, that the matter can be resolved. And then we can conclude it, disperse the money, and move on. However, most of the reality is we at least have to then file, and if not, go through the full portion of litigation. And if we have to do the litigation, then it moves over to a litigation paralegal. And the way it's set up in my office is we each have our own paralegals. I know there are other offices that kind of have banks. And so that way, if one person leaves, they don't have to find a home for 50 something cases. They just have to find a home for like 5. In my firm, we have our own paralegals. So I have my beautiful, lovely best friend, platonic soulmate, Chelsea Kunicki, who's been with me for 9 years, and she's my paralegal. So at that point, if it's one of my cases, it'll go to her. It'll be filed, it'll be served, and then we'll take the steps through litigation.
And so that's interesting. So what I do in my firm is try to cross train. Everyone is able to handle different cases and get a broad exposure to everything, and then hopefully, knock on wood, form a holistic view of the law, and they'll get a better paralegal out of it. So, okay. So
that makes total sense. We actually are training right now and not only training, but actually bringing like case managers to trial and bringing them to court, because I think you're 100% right that when you do have departmental
Right.
delineations. They don't have a whole picture view of what is happening and why you need something or why something's important. And so we're
Hmm.
making a concerted effort at this point to be able to show them how their piece fits in the puzzle and have them watch other departments or have them come to trial so they
Right.
see why it is so important to get pictures of the car in the accident, right when you start talking to them, because 3 years down the road, somebody has a new phone and they don't have pictures anymore.
The car's
And
gone.
the car's gone, and I've
Hmm.
now that evidence is
I try to take them to court with me. Things like you're going to have to take your shoes off when you go through security. So be
so
sure
far
and
back.
wear socks because that mat is kind of icky. Just things like that. How to get to which elevators to take to which floors because our courthouses are kind of a kilter like that. So things like that. Where to sit in the courtroom, the plaintiff over here, the defendant over there, or wait for the judge, that kind of thing. Watch another trial, watch another hearing just to see how things look. All courtrooms look the same to us, but it's a whole new experience if you haven't been there, all the time. So that kind of thing, get the where to park, get the client more used to the situation. So yeah, I'm a big believer in that and trying to walk the client through the whole process. You're not getting your money tomorrow. I'm real sorry. You're not going to get a divorce next week, regardless of what the other advertisements say of $699 divorce in 2 weeks. That's an uncontested divorce. You
Right, with
don't
no
have an
kids and like none of that, right?
right, right. You're looking at a trial or two trials in a year. And I imagine you have more competition in that area than family law in terms of promise the advertisements in personal injury, promising the sun and the moon, $1 million cases. Come on in and we can settle the case next week for 1/10 of the value if you want the
So
money right away.
or
So,
just right tomorrow, you'll have it tomorrow. So I think it's really important, like you said, in really setting up appropriate client expectations and being
mhm,
honest with clients. When we get intake calls and the attorney takes them because there's, kind of a gray area or
mhm,
it's not so black and white that our intake team can assess it. One of the biggest questions that always comes up is, how much do you think my case is worth? And
right.
I'm like, I have no idea. And I said, and any attorney who tells you that they do at this early stage is
Mhm.
essentially lying to you. That's not being honest. It's not being truthful. I don't know. First of all, you could have $1 million case, but you could also not treat. And if you don't treat, you're not going to get that much money because there's no corroborating medical evidence.
Mhm. Mhm.
Unfortunately, you're going to go into court and you can say whatever you want, but they're going to have a doctor that's going to say it's all baloney.
Or why didn't you go to the physical therapist?
Right. It couldn't have been that bad. If it was that bad, you would have gone to the doctor. So don't get me wrong. The defense has a cake and eat it too kind of argument, because
Right.
then a lot of times they'll say, well, how did you get to that doctor? Oh, well, I asked my attorney. Oh, your attorney said you.
Uh-huh. Uh-huh.
Well, yeah, my attorney sent me because I've never been in an accident and I didn't know where to go. And this was the problem. And I don't have health. Well, you can't say insurance. Financially, it was difficult for me to figure out a place to go. So I think it's always best to have really honest conversations with clients, because the worst thing that can happen is you get to the point where you're negotiating a settlement and your client has an unrealistic expectation about what they're receiving or should receive. Client management is a very big key portion of this field and of handling cases, because specifically I had a client that I took over when I came to the firm,
Mm.
and he said, oh, well, I was told that my case should be worth $15,000. And so it got time to negotiate settlement, and he was looking at, like, he got to the table and he was upset that he was only getting 11 or 12,000, and he goes, I was told I would have gotten more. And I said, well, you should have gone to physical therapy.
Yeah.
Oh, well, I didn't go because I called them a couple times and they didn't answer, and then I just forgot about it.
Hmm.
Okay, well, I can only help you if you help yourself. I
Hmm.
can't create miracles. I can't make magic happen. And so that was a conversation again that I took the case over from the attorney who had left. And so that would have been a conversation that I would have had months and months and months and months ago and said, did you go to physical therapy? Okay, well, if you're not going to go to physical therapy, realize the negative ramifications on your case, and you're not going to get as much money as you could or should as you're not fully treating. So that way, when we get to the table and or we're talking about settlement or we're doing the disbursement, the
Hmm.
client's not angry. The client's not upset. They don't feel like they've been hoodwinked, because the reality is, especially as a personal injury attorney, we have this terrible reputation that we are money hungry and that we
Hmm.
take advantage of our clients. And don't get me wrong, there are firms that do that. There are
Right.
firms that are solely for their profit at the expense of their client, and they do
Hmm.
not, we are not that firm. The
Hmm.
client is important. The client is priority. The client should get the lion's share of the money because they're the injured party.
Right.
However, we all know when it comes to money, if there aren't clear communications, typically problems arise. And
Hmm.
that's the worst time, because that's the end of the line. We're done. I'm at the table with a check for you. I can't make more money up here. So one of the things that we strive to have is regular client communication.
Hmm.
And now, that's not necessarily between me and the client, but it's with the case manager and the client checking in. How are you
Hmm.
doing? How are you feeling? Oh, well, I was discharged from physical therapy, but my pain levels are still like a 7 or 8 out of 10. Well, then I'm going to get involved and I'm going to say, well, are you done treating? Well, I just want to be done. Okay, well, if you want to be done, that's fine. But realize you're not going to feel better and you're not going to get the full compensation that you should.
Yeah.
So you can be done, but this is what's going to happen. And so that way they keep hearing it, and I've at least explained it to them, to hopefully avoid having that kind of confrontation when it's either settlement time or disbursement time, that
Right.
they feel like
Hmm.
they weren't treated properly and that once again, we're being greedy and don't care about them.
As we try to do the same thing when they first hire us, we have a meeting. They get to meet, the people that are going to be involved in their case. They get to meet the paralegal. They start in with a giant questionnaire, and then we start discovery before discovery. We start gathering all the information. We know the questions that are coming. It's model interrogatories in family law, and so we answer those. We find out the school, the pediatrician, the Boy Scouts, the Girl Scouts, the soccer, the ballet, special needs, the doctors, etc. What do you do with your child? Give us a typical day. I have trial questions for custody that I ask on at the initial interview. So we know what's good and what's bad. And then we work, if it's a property case, equitable distribution, we start working, gathering that in the documents for the property also. We're doing this because this is what the judge wants to see. And, you own a house, what's it worth? What's the mortgage? Etc. You don't tell that to the judge, you may not get the house. This is why we're asking these questions. This is what we're moving towards. This is why we have to have this. Now, we already gave you my checking accounts. Well, yeah, but that was 6 months ago. We need them updated.
Right. It's an
Oh,
ongoing process.
right. Yeah.
And I don't think people realize, first of all, with discovery, it's always better to start earlier because you don't know what the defense is going to ask for. And it can be things
Hmm.
that take time to get a hold of. And typically defense attorneys can be a little bit flexible in responses, but you could
Hmm.
have, you can have an attorney opposing counsel who was like, no, the deadline's the deadline. And I'm
Right.
running to the courthouse to file the motion to compel. But they don't realize, and that's another discussion I have with my clients, is this is incredibly invasive. And I'm going to do everything within my power, particularly with, say, subpoenas, to file motions to quash and get them
Right.
tailored and
Hmm.
narrowed down, because they don't have a right to invade your privacy. And unfortunately, a lot of defense attorneys do that, is they use subpoenas to try to get leverage and invade people's privacy and make them uncomfortable
Hmm.
and kind of get dirt on them. So I fight very hard against those. But at the end of the day, if you say that you have anxiety and you've been seeing a therapist for 10 years,
Hmm.
all of that's the defense has a right to that. It may not
Hmm.
come in, but they have
Right.
a right to it. It's relevant. If you're saying that you had, I have a client, we're getting ready to go to trial at the end of January. She was pregnant when the accident happened. She's saying that she had pregnancy complications as a result. She has a prior pregnancy. That child, the child from the accident, that was in the accident, he's 2.5 now, but her previous child is 9. Unfortunately, they have a right to those records, because if you're
Hmm.
saying that you had prior, or you had pregnancy complications from the accident that you're saying never happened before, they
Right.
get those records. And most people are like, that has nothing to do with this accident, but it does. And
Hmm.
so that's another conversation to have with clients is, hey, are you claiming lost wages? Well, I am. Okay, well, what proof do you have? Well, I don't know. I get paid under the table. Cool. We're not claiming lost wages because you're not filing taxes and that's not
Hmm.
coming in. Or you can go file taxes and then I can file for lost wages.
Right.
So these are other conversations that we have to have about the realistic expectations regarding litigation, that they're going to try to dredge up as much dirt on you as they can. And anything that's in your past, I mean, say a person's 55 and when they were 16, they had a car accident and they hurt their back. And now they're
Yeah.
55 and they're saying their back hurts. They get
Hmm.
those records. It doesn't matter that it was 40 years ago. And so people have, it's difficult for them because it feels like an invasion of privacy, and it very much is. But part of my job is to make sure that the defense attorneys only get what's relevant, not even admissible, but just relevant.
I have that too with I know my spouse is working a second job or working under the table. And I said, well, what proof do you have? Well, I just know. Okay, well, you want to hire a private investigator for $4,000? They can sit out in front of the house, follow them to work. They bill in increments of 4 hours at $150. And is that what you want? I mean, I know a detectives, I can set it up right away if you want to do that. And I go, oh, well, maybe not. Some do. I mean, sometimes they do, sometimes they don't. Saying it and getting it in front of the judge, the judges only hear special information, and that's called evidence. You may have all this information floating around out here, but that doesn't get in front of the judge. Only the evidence gets in front of the judge. You have suspicions, you have circumstantial evidence, etc., but only the evidence gets in front of the judge. We have to get the evidence, or the judge doesn't. If you don't provide the documents in your request for production of documents, it doesn't get in front of the judge. you know, so
Right.
that kind of thing. Just managing the clients, and it's kind of like a journey in a divorce. Obviously, a personal injury, you file it, and you have a trial in a year, or you have the injury, and then you have to file it within 2 years, just when that statute of limitations, and then you have the trial. So there's a beginning, a middle, and an end. And so you're kind of taking the client along on a journey. This is what you got to watch out for. There's falling rocks over here. There's alligators over here. I'm your guide. If you follow me, we'll make it. If you don't, there's the tar pits will get you or whatever. So that's kind of the way I think of it. And I try to lay it out, I guess. I mean, not really checklist law, but try to lay it out as much as possible so they know what's coming, what to expect next, the strategy, the counter response. Like you say, going after all their psychological records since third grade when they kicked the student under the desk.
Well, good
Yeah.
for you with family law. That's not, as a product of, let's see, my parents got divorced when I was 7, separated
Mm.
when I was 5, dad's on wife number 4, mom's on
Oh,
husband
wow.
number 3. I applaud you for your ability to stay in that field. It is very emotional and it's very
Mm.
messy and dramatic. That is not something I could tackle. So I applaud
Mm.
you, and I think that it really speaks to your character and the fortitude of your character to
Yeah.
maintain such
That's the way I
a
look at it.
prolonged
I
career.
don't get emotional. I mean, it's like saying, I understand all of this, but we've got to get this done. This is the process. This is what the legislature has decided. This is what the governor signed in the law. This is the procedures the courts have decided on. I realize all of this is happening outside, but this is what it's going to take. If you want me to do it for you, I can do it for you. If you want another lawyer who's going to get emotionally involved and help you follow your husband around at night, sure, that there are lawyers that do that. That's not me. So that's kind of what I explain to the people ahead of time. And that's what you get if you come to me. It's not going to be the emotion. It's not going to be extravagant pleadings and false accusations and so on.
But it shouldn't be that. I appreciate your non-emotional approach because that's what the law is. The law
Right.
isn't emotion. The law is words on paper. And
Hmm.
especially with a bench trial, the judge isn't going to let emotion play into it
Right.
like it would for a jury. And I think having an attorney with that honest, straightforward approach is much better because I think,
Hmm.
especially in family law, if you do get that entrenched, you're too close to it. You can't get blindsided and you can't get blinders on, because then you can't properly represent your client because you have too much of an emotional investment, and it clouds your judgment
Hmm.
regarding the pros and cons of the case and the realities of it.
And we got time limits. You know, we have time limits on trials. We can't just go on for days and days and days. You have to present the following factors if you want child support, the following factors if you want equitable distribution. And you can't just dwell 2 hours on one factor. You got to keep things moving along. Expect me to interrupt you on the witness stand a lot
Right.
because I
I
got to get to this list right here.
That's a big problem, is clients trying to interject what they think is relevant or what they think is important. And I'm like, I understand that that's important to you, but for
Hmm.
your case, it's not a huge factor. It's not
Right.
particularly relevant. And I don't want that time to be eaten up and distracting to the jury when we could really be focusing on the key elements of this or the key damages.
Mhm.
So I completely get that.
And of course, Satan is sitting right over there. Now's your chance to unload
Oh,
on
I can't even
this.
imagine. Can't even imagine.
Okay, changing just topics just a little bit. Electronic evidence. Now I know you probably get all that now. The medical records all come electronically, and then hope is that right?
Famous lawyer answer, it depends.
Oh,
It depends on the provider, and it depends on defense counsel, because
no.
going back to those subpoenas that we that get issued by defense counsel. I mean, I think I have one case where the guy just filed 28 of them,
20 what?
and 28 subpoenas for medical records.
Oh, uh-huh.
And they request them. I've a gentleman who's very old school. He's been practicing a long time. He does everything in paper. And so he
Oh, wow.
requests the medical records be sent to him as paper. So when I get them, they are paper. We
Uh-huh.
do convert them to electronic files, but
Hmm.
for the most part, it is electronic. It's quicker, it's cleaner, it's cheaper, it's easier. Like, I'm doing this podcast on a tablet. This tablet goes with me to trial. I can
Right.
flip through it, I can look through it. Now, that's not to say that I don't show up with trial binders that help keep me organized and prioritize what I want to speak about. But say I'm going to a motions argument and a defense attorney brings up an email or brings up something, some record somewhere, and I don't have it on me. Yes,
Right.
I can look it up in my files. We also do a lot of electronic presentations. We
Oh,
don't
really?
hand out a lot of paper evidence anymore. It's cumbersome, it's messy. You think about it, you have these trial binders, and one goes to the judge and one goes
Yes.
to defense counsel. And then
Oh,
in federal court, for instance, every juror had to have a trial binder with
wow.
the evidence. So you're making, 20 binders. And fortunately, that the federal trial didn't have a ton of evidence. But what if you're now into multiple binders? And so now you've got 60, 90 binders that you're carrying around. For the most part, we try to present electronically. Now, that doesn't always work because every court doesn't have the same kind of system set up.
Right.
I know Fairfax, which, by the way, I just took Katie Carroll for the first time, and she laughed that it was like the airport going through. Like you said, you got to take off shoes and belts and jackets. But some of the smaller locales, such as like Southampton or
Hmm.
or places like that, they don't have the AV technology. Most
Right.
courts do, that you can just plug something in, whether it's a USB, whether it's your computer,
Hmm.
and they have screens. Some courts, even every juror has their own screen.
Yeah. Hmm.
So we put up pictures of the cars. We put up, maybe there's a video. To try to disseminate a video in any other way other than electronically is a
Right.
nightmare, pretty much impossible. I have a case now where a woman was backed into at a parking lot. There's a video of it. Of course, I'm going to play that video, but that's going to be on the big screen for everybody to see. Now, we may print up pictures just for effect, like a 3x5 poster. Say if it's a really horrific crash of the car afterwards.
Right. Hmm.
And we'll leave it sitting in the corner of the courtroom. We'll put it up on an easel, and then we're just going to leave
Right.
it there. And
Uh,
the jury can just look at it periodically.
hmm.
Another big thing that we present, which you have to do electronically, are going to be medical demonstrations.
Hmm.
So medical procedure demonstrations, whether it's a surgery, whether it's nerve injection shots, epidural shots. I don't think people necessarily realize what a epidural steroid injection entails, that it's under fluoroscopy, that they do an ultrasound to make sure that they're putting it in the right place. And particularly when it's in your spine, they're going between the
Vertebrae.
vertebra and the spinal column. And,
Hmm.
most people are like, oh, it's a shot, like the flu shot. And you do, so to have a video where it plays through and have a doctor testifying and be like, and then I did this, and then I did this, and then I did this. But then on top of it, we've also had demonstrative evidence and graphics where the person's getting 2 shots, 3 shots a year, but say it's projected they're going to do that for the next 20 years. And all those shots will just stack on top of each other. So you have this visual impact, first
Hmm.
of all, of how in depth this procedure is, that the person has to go under anesthesia and how they actually administer the shot. But then it's going to be how many of them over time just stacking on top of each other. Another big one for our firm is traumatic brain injury graphics. People don't realize if you get a concussion's a mild traumatic brain injury, period. And unless you have a brain bleed, 99% of the time, you're not going to see any injury on an MRI or any type of typical imaging that would be performed. There
Hmm.
are special MRIs called neuroquants, but even those, they measure volumetric changes, not necessarily the actual damage. When you have a traumatic brain injury, which by the way, you don't even need to hit your head to have one. If you just have whiplash, motions, you can have a concussion. It's literally the neurons and the fibers being sheared. And so you're not going to see that on any MRI. And so to have that play in the background with a neurologist or a neuropsychologist explaining, this is what happened, this is what was injured, this is how the injury occurred. Because then not only once that neuron is sheared and broken does it die, it actually releases chemicals that kill the neurons around it. And so to have that visual impact so people can see exactly what happened, because it's not like a broken arm. Like,
Hmm.
do I have a client who just came in that she had to have rods in her arm that stick up, that she has to screw and reset her arm?
Uh,
Yes. Are those wonderful pictures to show to a jury to explain the injuries that she's received? Absolutely.
yes.
When
Hmm.
you have a brain injury, it's not evident, it's not clear. You can't just see it. So to
Hmm.
have these visuals that we can play are super important. But overall, I prefer most of the evidence to come in electronically. It doesn't always happen, but we're definitely moving in that direction.
Hmm. Let me warn you, Fairfax has spent millions of dollars outfitting their courtrooms, but then they give you this warning that if anything goes wrong with
You're on
their
your own.
system, the trial's still on.
Right.
So you'd better bring paper. So and you should be showing up the day before with that computer,
Mhm.
testing it out in that courtroom on that machine, on that whatever you the video to make sure it works. Because if it doesn't work, the trial's still going on. So everyone just brings paper,
Well,
even now.
I'm sure I mean, as a seasoned trial attorney, you always have to be prepared to pivot and don't have one way to do something.
Right,
You need
right.
to have two, three, four, five different ways, whether it's showing evidence, whether it's getting evidence in, whether it's getting, the answer that you need. You
Hmm.
have to be able, and I think that's a problem I see with a lot of attorneys. You hear that somebody says, I want to be a litigation attorney. And in theory, they do, but then
Right.
they get there and they go, "Oh my God, there's too much anxiety, there's too much pressure. I can't maneuver. This is my script. If it's off script, I'm kind of
Right. Yeah.
lost."
I
And
can't get the client to say what I want.
right. And it is frustrating to no end, but that's part of your job. Part of your job is to make sure you get in what you need to get in,
Right.
regardless of how you do it. And you
Hmm.
may have to take 5 or 6 end runs to get that to happen, but that's part of your job, is to be prepared to do that. Whether it's a piece of paper, whether it's this person's testimony, if it's electronic, if it's physical, whatever it is, you have to make sure that you're prepared. But yes, those little tiny places, the smaller locales, they say you're in charge of your own stuff. You can
Right.
show it on a computer, but you're going to figure out how to get it here. You're going to set it up. You're going to do it. That's even happened with witnesses who are out of state, that the judges are like, they can appear by Zoom, but you're the one who's got to get them here and get it set up.
Uh-huh. Uh-huh.
And then I've got like my little computer up on the bench, and the judge is like staring at them in the face on the bench. It's so
Well,
awkward.
the judges' clerks are very good at that. And they usually handle it now in the courtroom. So everybody just kind of sits here and looks around, and the judge's clerk is trying to get the person on the Zoom, and it worked. And then they hook them up to this audio or the visual in the courtroom. So that works out most of the time. If not, you just go back to the default telephone, and then that always works too. But so what we have is, I think a lot of clients now are moving towards electronic everything. And so then having them transfer to us the pay stubs, bank accounts,
Mhm.
brokerage accounts, retirement plans, that is a challenge. And then, of course, you get it in the wrong format. And well, what is this? And
Or
it's
there's
the
a
newest.
password, or you don't have
Mhm. Oh, yeah.
access
Yeah.
to it. Yeah.
So that's and then getting it to the other side, we still have attorneys that will lie about receiving stuff. I had a case, we gave it to them by Dropbox. It was a lot of documents. They said, we never got it. So it's like, well, we have the chain of custody that Dropbox generates. So yes, you did. We went to court and the judge says, what did you say? I said, Dropbox. Yeah, that's what I thought you said. He had no idea what Dropbox was. So I
Uh,
lost.
so I have a very short list, a very short blacklist of attorneys that I have a lot of difficulty with.
Right.
And, and I'm sure it's the same way with family law. We're up against the same people all the time. It is
Mhm.
a very small circle, particularly with insurance defense. USAA has its own attorneys. Allstate has the same attorneys it always
Mhm.
uses. Progressive has in-house attorneys. Geico has in-house attorneys. So it's always the same attorneys. I think what's kind of been lost as of late in our profession is that you can be adversarial and zealously represent your client without being a jerk,
Right.
without being rude. I don't know if a lot of attorneys realize that. We're also going to need favors all the time. Like I have
Mhm.
3 kids and my kid's teething, my kid's sick. I need an extension.
Right. Right.
Well, nobody's giving you an extension if you're mean. They're just not. It's just
Mhm.
the reality. So it doesn't behoove you or your client to be rude because then the other side is going to dig in. Nowadays, with my short list, there's pretty much one singular firm that a lot of those attorneys
Mhm.
are from. And they do the same kind of thing. And I've been on phone conferences and they're like, well, I never got that email. You replied to it. What do you mean you never got that email? How that it included the scheduling for today. Here you are. So we do email only, and we do delivery and read receipts for them because I have to have that now
Right.
when I go to court or I have an argument against them or emotions hearing that they're going to, oh, well, I didn't get that. What do you want me to mail it to you? Who even knows how well the mail works these days? It could be 3 weeks later if you get it at all. So we email everything. We try to do that. We do have to say you have the defense has to agree to receive service and pleadings
Right.
electronically. However, that means that there's only 1 day service, if even. It means that you get everything electronically, which we all want anyways.
Mhm.
Like we now have Neos as our case management system, which is
Okay. Mhm.
fully cloud-based. We are moving away in our firm from electronic or from paper files.
Mhm.
Again, the resources and space alone it consumes to continue to generate paper files. It's bizarre to me that in this day and age, attorneys opposing counsel think that they can argue that they didn't receive something. Like you said, there's Dropbox or
Right.
there's SharePoint or or Outlook, where I
Mhm.
can literally, if I need to, go get the metadata and tell you the date and time that you opened it and looked at it.
Right. Right.
Now, that being said, is my inbox out of control? Absolutely. May I have not seen it?
Right.
Absolutely. But that's why it's important to me and imperative that people CC paralegals or case managers or other staff
Mhm.
members. If it's electronic, I don't even understand how attorneys think that they can make a valid argument that it's not received. That's just
Mhm.
silly. Stop it.
Yeah. We do it 3 ways. We do it regular mail, which is electronic mail. So we have the certificate of mailing by the third party company that comes in as business records. We have Ring Central, so electronic fax, which again has the electronic handshake between Ring Central and the other opposing counsel's fax that shows the transmission occurred. We can print that out if necessary. And then we have, like you say, the email, and we use Outlook, SharePoint 365, the newest one
Mhm.
there. So again, same thing. It's just like, really, you're gonna make this argument, you're gonna make us
Right.
print all this out and prove that you're a liar, and file it in court.
And then
Yeah,
you have no credibility with the judge
right.
because now the judge is like, what do you mean you did? Like, here's all the data that
Hmm.
you
Hmm.
received it when you received it.
Right.
But speaking of judges, sadly, especially now with a whole bunch of new judges coming up,
Hmm.
I don't know in Fairfax because, like I've already
A
told you,
lot of new judges in Fairfax. Yeah.
I avoid that jurisdiction like the plague.
So
So
does
I
everybody
go
else.
there. I have cases there. They're not my favorite, but a lot of new judges coming up. Even sadly, even older judges. I just assume for the most part that judges don't know what they're doing until they show me that they do. I've
Hmm.
just seen too many terrible calls and I've just seen too many terrible interpretations. A good key example was in Chesapeake Circuit Court. And I had a Chesapeake General District Court trial and I had won. In order to appeal to the circuit court, the defendant has to put up a bond, and that
Hmm.
bond is usually in the amount of judgment. She had an attorney, and the attorney is arguing, well, she doesn't have money for that kind of bond. And I was like, well, that's funny because you're here, you're an attorney, so she's paying you, so she got some money. Well, she can't afford it. It would essentially preclude her from being able to appeal. I said, okay, well, then you know what? If you want to have a separate hearing and you want to bring her financial information,
Right. Hmm.
then we can have that argument because the code on its face said it's the amount of the judgment, period. And so the new judge was like, well, I'm going to set it at $500. And I said, Your Honor, that's not the law. That's not what the law says. You can't arbitrarily pick a number. She said to me, well, if I don't set it at $500, it essentially precludes her from her right of appeal. I said, well, that sounds like a legislative issue, and you can go talk to the people up on the hill about it. Well, she set it at $500. So it went up to circuit. She paid the bond. And my argument was that it was not perfected because even though she'd noted the appeal, she had not posted the proper bond as per the code and that the judge was incorrect. And so I get up in circuit court and I'm making this argument, and I'm in front of the chief presiding circuit court judge at that time in Chesapeake.
Hmm.
And I'm making this argument, and I said it's not properly perfected because it wasn't the bond as the law lays out. And she goes, well, it says bond with surety. And I said, yeah, so she could have gone to a third party, like a essentially a bail
Right.
bondsman. She could have paid the 10% and then gotten the surety for the rest. She goes, no, surety, as in she's sure. She was confident that it was $500 would adequately compensate. I was like, oh my God, do I need a dictionary? Should I Google Merriam-Webster? Like this an older woman who was the chief presiding judge in circuit court looked me in the face and said, surety means confidence that you were, ma'am. And I've watched that. I had a judge in Petersburg. And so I put on a witness and exhibit list a 911 call transcript. And I put it on the witness and exhibit list. And there's a code section that says transcripts of those calls are self-authenticating if properly documented, which it was. We had the
Right.
seal from the Commonwealth of Virginia. It says it's self-authenticating. And the code specifically says aside and apart from the actual phone call. You don't even need to have the recording.
Hmm.
And so I put it on the witness and exhibit list, and it had been shared in discovery.
Hmm.
And so we get up there, and before the trial starts, out of the purview of the jury, this defense attorney makes an argument and says that shouldn't come in because it was a hit and run. It was a John Doe hit and run, and that call was evidence of a red car. Somebody called that a red car caused the accident. Defense's argument was that our client was leaving work at 2 a.m. and it was raining and she was tired and she drove off the road. The perfect example of uninsured motorist coverage that her policy had hired this attorney to fight her for her
Right.
money that she pays for. He made the argument that it shouldn't come in because he can't cross-examine it. And I said, well, it's on the witness and exhibit list and you didn't object to it. So I don't
Right.
really. And the judge goes, well, you didn't object to it. He goes, no, I didn't. He goes, but I can't cross-examine it. I said, it's a self-authenticating record per the
Hmm.
Commonwealth. Here's the code section, here's the
Right.
authentication, but I don't have the phone call to hear that the transcript is accurate. You don't get the phone call. The code section literally says you don't get the phone call.
Right.
He went through about 3 or 4 arguments before the judge was finally like, it's not coming in. It
Ugh.
literally says on its face, it was shared. He goes, I didn't get into discovery. I said, here's the
Yeah.
email with the discovery where you got it. Three
Hmm.
or four arguments down the line, the judge excluded it because he didn't have the phone call to corroborate it. I have watched time and time again, judges make terrible calls,
Hmm.
and it is disheartening and it's sad. And don't get me wrong, I know, especially in general, well, circuit or general district court, I am a civil personal injury attorney. That is my lane. That's what I know. I don't
Hmm.
know family. I don't know traffic. I don't
Hmm.
know criminal. And you get judges up there who are family lawyers or defense attorneys
Right.
who don't know the nuances. I used to do insurance subrogation. Even people who do personal injury don't know insurance subrogation.
Right.
And so I get it that you are coming into this position with a lack of foundation, as I would be a fish out of water in the same exact situation. However, I find that a lot of judges sadly take that opportunity as now they're the person in power and they're the person with the robe to make decisions that they aren't necessarily fully aware of the law or the case law or code sections that those decisions should be
Right.
based on. And they don't educate themselves because for the most part they don't really have any
Hmm.
ramifications or repercussions, especially general district court. That's another thing clients don't realize. General district court, there's no record unless I hire a court reporter, which depending on the case, I may or may not.
Right.
So those judges aren't on the record. So they really don't have any repercussions for bad decisions or bad
Hmm.
choice. And so my approach has been I have to bring every stitch of code section, I have to bring every case, like every case precedent. I have to bring everything in my arsenal that my arguments are based on because I'm assuming that that judge doesn't know any of them. And even when I bring them, a good majority of the time, judges still make wrong, inappropriate calls.
Hmm.
So it's sad but frustrating.
I've had some judges say, look, just pretend I don't know anything. If you want spousal support, print out the factors and insert your arguments. This is factor number one. And here's why my client deserves spousal support. Factor number two, okay, that doesn't apply. Factor number three, and you have to hand it to the other side, of course, but
Right.
hand it to the judge. Here's what I'm going to prove, and you can see the judge just check off or X off. And again, situations where you only have 3 hours for a custody trial or something like that. I mean, it's insane, but that's what you got. That's what you got to do. Hour and a half for my side, hour and a half for the other side. You get the client as a witness to testify and maybe one more, and that's it. that's
Wow.
that's the custody of the child. So go. And the judge is the timekeeper. So those are the constraints. But and then the clients come in with electronic evidence, their cell phones,
Mhm.
and they're doing this. And how do you get that off of the cell phone? Oh, we'll email it to you, and that doesn't come out. So yeah, I had one client recently with a iPhone, and her entire case was on the cloud on her iPhone. And she would say, "Oh, well, I can send that to you." And she'd send it, and we get a gigabyte of documents. Who's supposed to go through this?
I tell people if there's something pertinent, like for instance, an exchange with the person who hit
Right.
them, take a screenshot of it
Hmm.
and then send it to me and I'll print it out. But like you said, everything's on cell phone. So I remember this is going to kind of age me a little bit. When I first started driving, my mom was like, get a disposable camera and keep it in your glove compartment. So that way, if you're in an accident, you can take pictures.
Hmm.
Because at the end of the day, the pictures do speak 1,000 words.
Right.
And even
Hmm.
if particularly if it's a liability dispute that you each say you had a green light or you say you were going straight and they say you were
Right.
turning.
Hmm.
It's incredibly important. And so that is always something that gives me pause if we have a client who's like, I was in this catastrophic accident, it was crazy, my car is total, and I'm like, cool, where are the pictures? But I
Uh,
didn't take any pictures. So many people walk around nowadays with their phones glued to their hand.
exactly.
So for you to tell me that you were in this horrific accident, unless your phone somehow got broken in this accident, how you
Right.
don't have pictures blows my mind.
And so did everyone else around you.
Right. But you know what? I do find though it is really sad. A lot of people don't stop. A lot of people don't stop. There aren't a lot of good Samaritans. Now, that being said, do we have cases where there's a hit and run and somebody does get the plate and does follow them and does send them pictures? Yes. But for
Right.
the most part, a lot of people can't be bothered, which is, I understand if it's a minor accident, but some of
Hmm.
these more significant accidents, the fact that nobody stops, I think,
Yeah.
so kind of speaks volumes about our current social state.
Hmm.
Um, but no, having the phone is very crucial, and we do have these communications where people are texting with the person who hit them, where the person who hit them says, "I'm so sorry, it was all my fault. I wasn't looking, or this happened, or my kid was in the back seat, or something."
Hmm.
And then they get to court and they're like, "Wasn't my fault." And I'm like, "Oh, let's look at this lovely." And then they're like, "Oh."
Right. Hmm.
So no, it is nowadays. I've watched friends of mine go through divorces, and it is all on the phone. They're texting with the other spouse. It's
Yeah.
your banking information. It's everything on the phone. So I would
Hmm.
imagine that those are crucial pieces that you need to bring in. But like you said, it's how long have you been texting your spouse, and then you're just dumping it on
Yeah,
me.
they now have in family law sort of a online, it's called My Family Wizard, but there's other companies too. And the goal is communication. So you put the school schedules, you put the doctor's appointment, you put pictures of the soccer practice, the emails from the school teachers. It all goes onto this central database, and reminders can go out. And that, well, my wife never told me about the doctor's appointment. Here it is.
That's
you know,
really smart.
um, or maybe she really didn't, in which case, sign up for Family Wizard today. You're going to have the trial in December 2025. So now you've got your chance to build your record for the court. And the judge can see that now you're a good parent because look at all the stuff I've done and everything I put in my Family Wizard, and the other side didn't. But again, if you don't use it, it's almost worse than not having it at all, because then you've got a lot of blanks, where you should have,
Right. Then it's
weekend
proving
visits.
you're not
Yeah.
contributing and participating.
So, how do you feel about trials in person versus trials on Zoom or online?
For the most part, we try to do everything in person.
Hmm.
General district court where it's just a judge is different.
Hmm.
Again, it's not emotional. It's the judge is removed. The judge understands. The judge knows the law. I will say currently I have one circuit court case that is a bench trial because it's practically no property damage.
Hmm.
And so I know in front of a jury, the defense would be like, look at this, there's no damage. She never made a claim. It doesn't corroborate with the back injuries that she's claiming.
Right.
We have her doctor to say it does, but that would be a big issue. That's a trial that I wouldn't care if it were
Hmm.
Zoom or electronic. Again, it's a judge. It's one or two witnesses. Three witnesses. It's
Hmm.
not a lot of evidence. However, particularly with jury trials and trying to elicit and demonstrate the emotion involved. I would say more of the catastrophic or significant cases. For instance, I had a woman that was T-boned at 55 miles an hour.
Oof.
She had previous pelvic issues, but it resulted in significant pelvic issues and multiple surgeries. Not being able to wear pants, not being able to go to the bathroom comfortably. It's
Hmm.
horrendous. Do I want her to exaggerate her emotional response? Do I want her to be contrived and, cry
Right.
crocodile tears? Absolutely not. But when asking her these questions, it does evoke a response because it is very traumatic. And for her to sit in front of a jury and a jury to see her reaction and see her mannerisms,
Right.
see that raw emotion is really important. It's really key. I have the trial coming up in January. I have one doctor that I have to do by Debeni essay videotape
Hmm.
deposition because he's out in Colorado.
Right. Hmm.
I ain't flying him back. That's like 4 days that I'd have to pay for that. That's going
Hmm.
to the cost benefit analysis. He's going to be by DVE. But specifically, her other treating provider, who is local, is going to be in person.
Hmm.
So again, he can point to the board and he can show the video and can explain and be there to answer questions.
Right.
I think that for the most part, I'd prefer to have it in person. Another issue with electronic appearances is evidence. Trying to show a client or trying to show a witness a piece of evidence. Oh,
Right.
I can't see it. It's grainy. I can't
Hmm.
read that. I
Hmm.
can't, we'll send them a binder with the evidence, but how do you verify that they're looking at the same document or the
Right.
same
Right.
picture? Or it's much cleaner to try to move. And again, going back to what I said, always have multiple ways to get something in. I'm not just going to depend on that person.
Hmm.
But what if, for instance, my client's in the military and they're now stationed overseas and there's
Right.
nothing I can do about it? They're going to have to appear electronically.
Hmm.
And I haven't come across this yet, but maybe at that point, do like a shared screen so we can all see that we're looking
Right.
at the
Right.
same thing. It doesn't typically have the same impact emotionally that I want a jury to be able to connect
Hmm.
with. Having somebody crying or upset on a screen is much different than seeing them in person. And that's part of it for a jury. A part of it for a jury is seeing that the person's response comports with their behavior and with their actions.
Hmm.
And the impact is much more real and substantial when they're sitting face to face.
Right.
I prefer to have in person, but if it's somebody that's out of state for whatever reason, or if it's cost prohibitive, that could be another thing. There are cases where medical experts are $10,000 to come to trial.
Right.
The
Right.
case may not support that. So instead, it may be $2,000 to have him do a videotape deposition. So I'm
Hmm.
not eating up his whole day. For the most part, I think it's better to have them in person. I prefer that when we
Hmm.
can.
Yeah, well, I mean, everything I have is bench trials or motion. You go all this trip to the courthouse for a motion, 5 or 10 minutes, the
Mhm.
decision, or you work it out, and then everything travel time back home. So that's kind of what I'm seeing, and I've even heard like bankruptcy courts now they want it in the courthouse. Why? I mean, there's no emotion.
I don't disagree with you.
Yeah.
I went to law school in Florida, and Florida being such a long state it's not abnormal for people to appear electronically, whether
Mm-hmm.
by phone or video, lawyers, witnesses, everybody, because you can't be in Tampa and Miami in the same day. It's just
Right.
not
Mm-hmm.
physically possible. Now, before COVID, Virginia absolutely hated electronic appearances. And I had to fight tooth and nail for clients who were stationed overseas to be able
Mm-hmm.
to appear remotely.
Right.
Courts hated it. I think with COVID, it's gotten a little bit more lax and they've
Mm-hmm.
become more understanding about it. However, I feel for the most part that courts still prefer to have people in person. Now, that being said, I agree with you wholeheartedly. The defense filed a motion
Mm-hmm.
for this case coming up in January. The case is in Mecklenburg. I'm in Richmond. That's a 2 hour drive for me. It was a baloney motion. It was a motion for summary judgment for contributory negligence.
Which you don't get in Virginia.
Right, which you don't get. It's not
Uh,
there. It doesn't happen.
hmm.
But I had to drive 2 hours.
Mm.
It was literally a 5 minute hearing because that's what the judge said. The judge is like,
Hmm.
this is not a thing.
Right.
And I drive 2 hours back. So that's 4+ hours of my day that
Hmm.
I have now wasted sitting in a car for sorry, my very eloquent way of putting it, for a Bobo motion that didn't mean
Hmm.
anything, that wasn't going to go anywhere, but I still had to respond to it. So that, yes, would I have loved for that to be a phone call like, yo, judge, this
Hmm.
isn't a real
Hmm.
thing. Thanks.
Yep.
But unfortunately, and especially in Mecklenburg, which again is a smaller locale, which is more old school, they
Mhm.
really want, butts in the seats, for lack of a better way to put it.
Yep. Yep. Very picturesque. Well, just kind of to wrap it up, would you go into this again? Would you be a lawyer again? Would this be something that you would want to repeat?
I would. And I think there's a couple of reasons behind it. Like I already said, I came into this at 31, not
Hmm.
24, 25, 26.
Right.
So I really got to figure out what I wanted to do. And I've really had the opportunity to kind of do it my way, which I think has
Mm.
made a huge difference. Prior to this, anybody who looks on our website, you can see I had pink hair. So I'm out of the box and I am different and I'm unorthodox. And as a lawyer should be, I'm opinionated and stubborn. I've been very fortunate that I've had bosses who allow me to be myself and allow me to
No.
do things the way that I want to do and not tell me how to do things. If I were in a circumstance where it was dictated to me how I was to conduct myself in my cases, absolutely not. But the
Hmm.
fact that I have had enough of a voice and enough respect from my bosses and employers to be able to handle cases the way that I want and approach them the way that I want, I think has made a huge difference. I'm also not in it for the money. Don't get me wrong. I'm very comfortable, but
Right.
that's not my goal. My goal is I'm driven by justice and righting wrongs and helping injured people. So I think if, again, going back to the authenticity and your motivations for being in the profession play a huge part and a huge factor in me enjoying my job. I love my job. I love my
Mm-hmm.
job. I wake up every day excited to do it.
Mm-hmm.
It's demanding. It's stressful. I practically work 24/7 when I'm not with my kids or focusing on my kids,
Right.
but I enjoy it. So yes, I would 100% do this again if given the opportunity.
Mm-hmm. I think I would too. I mean, there
Right.
days yes, days
Yes.
no. But in general, I like giving advice to people, and I like getting paid for it sometimes too.
I
That's
like I like being paid to be right. I
right,
like winning
exactly.
arguments.
Yeah, yeah. I mean, sometimes I tell people, forget it. It's not worth the divorce. I'm sorry your wife's not talking to you, but you're married. You should have known this when when you got into this. Who told you it was sunshine and roses? You know.
Right.
So that's the kind of thing. And I guess I get good reviews because I don't take cases. So that's something also. But yeah,
Every case isn't a case. And I
that's
think,
right.
and I think a
Yeah.
lot of people aren't honest about that because a lot of attorneys do just want the money. So
Hmm. Hmm.
I think that it's enviable that you do have that approach because that should be the reality. I tell my clients,
Hmm.
you're going to make more handling this yourself than I can do for you. We're going to come to the same amount at the end, but instead you're going to have to pay my fee. Go call
Right.
the insurance company and handle it yourself. I'm not adding any value to your case.
Hmm. Hmm. Yep.